Welcome to Sexual Harassment Prevention in the Workplace. Sexual harassment remains one of the most pervasive occupational hazards facing healthcare workers in the United States. Among all industries, healthcare consistently ranks among the highest risk settings for sexual harassment and workplace sexual violence. And that distinction isn't driven by the individual conduct of healthcare professionals. It's driven by the structural characteristics of the environments in which they practice. Steep organizational hierarchies, prolonged physical proximity during patient care, isolated treatment environments, night shift staffing patterns, and the routine use of therapeutic touch create conditions where harassment can emerge, persist, and go unreported. For physical therapists, occupational therapists, nurses, and other allied health professionals, these risk factors are compounded by the frequency with which practitioners work alone with patients behind closed doors, perform intimate assessments, and depend on supervisors for evaluations, clinical hours, and career advancement. The consequences of workplace sexual harassment extend well beyond the individual who's targeted. A strong and growing body of evidence links sexual harassment to clinician burnout, depression, post-traumatic stress disorder, suicidal ideation, cardiovascular disease, substance use, workforce attrition, and degraded patient safety outcomes. The magnitude of these effects isn't trivial. Prospective cohort studies have demonstrated nearly threefold increases in suicide risk among harassed workers and dose-response relationships between harassment exposure and burnout that are strong enough to explain the gender gap in physician burnout entirely. Despite the scale and severity of the problem, fewer than 10% of harassed healthcare workers formally report incidents. The same hierarchical and culturally permissive conditions that enable harassment also suppress the reporting behaviors necessary to address it. The research literature calls this dynamic institutional betrayal. This course equips allied health professionals with the legal, clinical, and organizational knowledge necessary to recognize sexual harassment in all of its forms, understand the reporting and protective frameworks available under federal and Illinois law, and identify the employer-level prevention strategies that the evidence shows are most likely to reduce incidents. The course is organized into 5 modules. Module 1 examines the legal foundations and definitions of sexual harassment under federal Title VII and the Illinois Human Rights Act. Module 2 reviews the prevalence, health consequences, and structural risk factors specific to healthcare. Module 3 addresses the recognition of harassment in clinical settings, including third-party harassment by patients and visitors. Module 4 covers reporting procedures, anti-retaliation protections, and documentation practices. Module 5 addresses employer obligations and evidence-based prevention strategies. Upon completion of this course, you'll be able to define quid pro quo and hostile work environment as the 2 principal forms of workplace sexual harassment. You'll be able to identify organizational and environmental risk factors for sexual harassment in healthcare settings and describe the health, psychological, and professional consequences of workplace sexual harassment for healthcare workers. You'll also be able to recognize verbal, physical, visual, and digital forms of sexual harassment in clinical work environments, list the recommended steps for reporting workplace sexual harassment through internal and external channels, and explain employer obligations for preventing and responding to workplace sexual harassment. Finally, you'll be able to state the anti-retaliation protections available to healthcare workers who report workplace sexual harassment. This module establishes the legal framework that defines and prohibits sexual harassment in the workplace, covering federal Title VII, the Illinois Human Rights Act, and the Supreme Court decisions that shaped current standards. Sexual harassment is a form of sex discrimination, prohibited by Title VII of the Civil Rights Act of 1964, codified at 42 U.S.C., Sections 2000E through 2000E-17. Title VII makes it an unlawful employment practice for an employer to discriminate against any individual with respect to compensation, terms, conditions, or privileges of employment because of sex. The statute applies to private sector employers with 15 or more employees, state and local governments, employment agencies, labor organizations, and the federal government. Title VII itself doesn't contain a standalone statutory definition of sexual harassment. The operative definition comes from the Equal Employment Opportunity Commission, or EEOC, in its regulations at 29 CFR Section 1604.11. Those regulations describe sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature, when submission to the conduct is made a term or condition of employment, when submission to or rejection of the conduct is used as the basis for employment decisions, or when the conduct has the purpose or effect of unreasonably interfering with work performance or creating an intimidating, hostile, or offensive working environment. The first 2 prongs of the EEOC's definition describe quid pro quo harassment, while the third describes hostile work environment harassment. The EEOC further specifies that harassment need not be sexual in nature. It can include offensive remarks about a person's sex or gender. The United States Supreme Court first recognized hostile work environment sexual harassment as actionable sex discrimination under Title VII in Marital Savings Bank versus Vinson, decided in 1986. Merita held that a plaintiff may establish a Title VII violation by proving that sex-based discrimination created a hostile or abusive work environment, and that tangible economic loss isn't a required element. The court framed the central inquiry as whether the conduct was unwelcome, not whether the complainant's participation was voluntary, and established that the conduct must be sufficiently severe or pervasive to alter the conditions of employment. Harris v. Forklift Systems Incorporated, decided in 1993, refined the hostile environment standard by establishing a two-part test. The conduct must create an environment that a reasonable person would find hostile or abusive, which is the objective component, and that the victim subjectively perceived to be abusive, which is the subjective component. The court directed lower courts to evaluate the totality of the circumstances, including the frequency of the conduct, its severity, whether it's physically threatening or humiliating, and whether it unreasonably interferes with work performance. Same-sex sexual harassment is actionable under Title VII. In Oncala v. Sundowner Offshore Services Incorporated, decided in 1998, the court held unanimously that nothing in Title VII bars a claim of discrimination because of sex, merely because the harasser and the target are of the same sex, provided the plaintiff proves the conduct constituted discrimination because of sex, rather than conduct that merely had sexual content. Title VII's protected class framework rests on sex as a protected characteristic. After Bostock v. Clayton County in 2020, sex under Title VII encompasses sexual orientation and gender identity for purposes of discharge decisions. The extension of Bostock's reasoning to harassment specifically had been addressed in the EEOC's 2024 Enforcement Guidance on Harassment in the Workplace. However, on January 22, 2026, the EEOC voted 2-1 to rescind that guidance in its entirety. The Commission's announcement emphasized that rescission doesn't authorize unlawful harassment and that federal employment laws and Supreme Court precedent remain in force. Let's shift to Illinois state law. The Illinois Human Rights Act, or IHRA, codified at 775 ILCS 5/1-101 etiesec, prohibits sexual harassment in employment and is enforced by the Illinois Department of Human Rights, or IDHR. The Act defines sexual harassment as any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature, when submission is made a term or condition of employment, when submission to or rejection is used as the basis for employment decisions, or when the conduct has the purpose or effect of substantially interfering with work performance or creating an intimidating, hostile, or offensive working environment. The definition expressly states that working environment isn't limited to a physical location to which an employee is assigned. Here's where the IHRA diverges from Title VII in ways that matter for healthcare employers in Illinois. While the IHRA's general employment provisions apply to employers with 15 or more employees, the Act's sexual harassment provisions apply to all employers regardless of size. That means even a solo practitioner with a single employee is covered. Second, Section 2-102D-5, added by Public Act 101-0221, the Workplace Transparency Act, expressly prohibits sexual harassment of non-employees performing services for an employer, such as independent contractors and consultants. Third, the IHRA imposes strict liability on employers for sexual harassment committed by managerial and supervisory employees, while liability for harassment by non-managerial co-workers and non-employees attaches when the employer becomes aware of the conduct and fails to take reasonable corrective measures. Fourth, effective January 1, 2025, the statute of limitations for filing a charge with the IDHR was extended from 300 days to 2 years under Public Act 103-0973, while the Title VII deadline of 180 days, extended to 300 days where a state or local agency enforces a parallel law, remains unchanged. The 2018 National Academies of Sciences, Engineering and Medicine, or NASEM consensus report titled Sexual Harassment of Women, Climate, Culture and Consequences in Academic Sciences, Engineering and Medicine broadened the conceptual framework beyond the legal binary of quid pro quo and hostile work environment. NASEM identified 3 major forms of sexual harassment. The first is gender harassment, consisting of verbal and non-verbal behaviors conveying hostility, objectification, exclusion, or second-class status about members of one gender. The second is unwanted sexual attention, consisting of unwelcome verbal or physical sexual advances that can include assault. The third is sexual coercion, meaning conditioning favorable professional or educational treatment on sexual activity, which is equivalent to the legal concept of quid pro quo. Under this framework, gender harassment and unwanted sexual attention both fall within the hostile work environment legal category, while sexual coercion maps to quid pro quo. The NASEM report highlighted a finding with major implications for healthcare institutions. Gender harassment is by far the most common form of sexual harassment and the primary driver of the high sexual harassment rates documented in medicine. This form is frequently normalized or dismissed as just culture, rather than recognized as a category of sexual harassment. What that means in practice is that institutional prevention efforts narrowly focused on quid pro quo or unwanted sexual attention will fail to address the dominant mechanism through which harassment operates in clinical environments. Let's now examine how these legal frameworks apply specifically to healthcare settings. Both Title VII and the IHRA apply to healthcare employers, including hospitals, outpatient clinics, skilled nursing facilities, home health agencies, and physician group practices that meet applicable coverage thresholds. Physical therapists, occupational therapists, registered nurses, licensed practical nurses, certified nursing assistants, respiratory therapists, speech-language pathologists, and other allied health professionals who are common law employees are covered under Title VII. Independent contractors aren't employees under Title VII, but in Illinois, the IHRA's non-employee provision supplies parallel protection. Quid pro quo harassment in healthcare typically arises in supervisor-subordinate relationships within a strongly hierarchical clinical environment. A chief of service, clinical preceptor, or director of nursing who conditions preceptorship, shift assignment, evaluation, promotion, or continued employment on a subordinate submission to sexual conduct engages in quid pro quo harassment. Because healthcare careers depend on documented clinical hours, evaluations, and references, the power available to a supervisor is substantial. Under Burlington Industries Incorporated versus Eleth, decided in 1998, and Farragut versus City of Boca Raton, also decided in 1998, an employer is strictly or vicariously liable when supervisory harassment culminates in a tangible employment action. Hostile work environment harassment in healthcare may arise from coworker, supervisor, or third-party conduct and is shaped by the high-frequency physical proximity nature of patient care. Touching during patient handoffs, exposed body assessments, intimate care tasks, late night and isolated shift work, and small clinical teams all produce contexts in which severe or pervasive harassment can develop. The severity and pervasiveness analysis is disjunctive. Conduct may be actionable because it's sufficiently severe, where a single sexual assault may qualify on its own, or sufficiently pervasive, meaning a course of less severe conduct over time. The more severe the conduct, the less frequently it must occur to be actionable, and the less severe it is, the more pervasive it must be. The Farragut-Eleth affirmative defense provides an important compliance framework for healthcare employers. When a supervisor's harassment doesn't culminate in a tangible employment action, the employer may assert the defense by proving both that it exercised reasonable care to prevent and promptly correct harassing behavior through written policies, multiple complaint channels, training, and prompt investigation, and that the employee unreasonably failed to take advantage of preventive or corrective opportunities. The defense is unavailable where the supervisor's harassment resulted in a tangible employment action. For Joint Commission accredited hospitals subject to workplace violence prevention standards effective January 1, 2022, the programmatic features required for accreditation overlap substantially with the elements necessary to establish the defense. This module examines the prevalence of sexual harassment across healthcare professions, its documented consequences for clinician health and patient safety, and the structural and cultural factors that make healthcare a high-risk industry. The peer-reviewed healthcare literature consistently reports that sexual harassment is a common occupational exposure across nursing, medicine, and the allied health professions, with substantial variation by setting, profession, measurement approach, and reference period. Healthcare has among the highest rates of sexual harassment of any industry. A systematic review and meta-analysis of 253 studies, covering 331,544 participants, found that approximately 1 in 8 healthcare workers, or 12.4%, experienced sexual harassment by patients and visitors in the preceding 12 months, a finding that was statistically robust and consistent across the studies analyzed. A separate systematic review and meta-analysis encompassing 129 studies and 333,649 women reported a pooled prevalence of workplace sexual violence among female healthcare workers of 30%, with the true figure reliably estimated to fall between 24 and 38%. That exceeds the cross-sector pooled prevalence of 26%. Nurses bear the highest burden of sexual harassment among healthcare occupations. A 2020 meta-analysis found 12-month prevalence of 12.6% and career prevalence of 53.4%. Karsai and colleagues reported a pooled prevalence of approximately 43% against female nurses, with study-level estimates ranging from roughly 10% to 87%. In a multi-center study across 4 German university hospitals, 2,365 nurses reported that 77.1% of female nurses and 68.2% of male nurses had experienced sexual harassment. In inpatient psychiatric settings, prevalence of sexual violence against mental health nurses ranges from 0% to 68%. Among physicians and academic medicine faculty, the burden is equally substantial. A 2023 study of National Institutes of Health Care awardees, early career researchers holding NIH career development grants, found that approximately 58% overall reported at least one form of workplace sexual harassment within the past 2 years, with 72.7% of women and 45.4% of men affected. Gender harassment was the most common form. The Harassment study, named for the social media movement addressing sexual harassment in academic medicine at the University of Michigan, surveyed 705 faculty and found 82.5% of women and 65.1% of men reported at least one incident from insiders in the preceding year alone. The NASM 2018 consensus report found that 20 to 50% of students in science, engineering, and medicine reported experiencing sexual harassment, with medical students reporting significantly more harassment than students in other disciplines. Surgical training programs present particularly high rates. The Hugh and colleagues' landmark New England Journal of Medicine 2019 survey of 7,409 general surgery residents across all 262 United States programs, with a 99.3% response rate, found sexual harassment reported by 10.3% overall, with 19.9% of women and 3.9% of men affected. When behavior-specific queries were used in a 2021 follow-up of 6,956 residents, rates were substantially higher, 42.5% of female residents and 21.5% of male residents. Among U.S. medical interns from 28 institutions, 64.7% overall experienced sexual harassment, with 77.2% of women and 50.9% of men reporting it, and significant institutional variation. Physical therapists and physical therapist assistants face exceptionally high rates of inappropriate patient sexual behavior, or IPSB. Boissonneau and colleagues reported career prevalence of 84% and 12-month prevalence of 47% among physical therapist clinicians and students in the United States. Risk factors included fewer years of experience, routinely treating cognitively impaired patients, being female, and treating male patients. Yet fewer than 1/3 of physical therapists had received any training on handling such situations. Home healthcare workers in high-income countries report a pooled sexual harassment prevalence of approximately 10%, though estimates varied considerably across the available studies. So what does that mean in practice? The magnitude of underreporting remains one of the most consequential features of workplace sexual harassment in healthcare. Only 8 to 10% of harassed healthcare workers formally report incidents. Among respondents in the Harassment study who did formally report, 42.9% of women and 53.1% of men experienced institutional minimization, and 21.8% of women and 43.8% of men experienced retaliation. The prevalence data tell only part of the story. Sexual harassment is one of the strongest modifiable predictors of burnout in healthcare workers, with evidence of a dose-response relationship. In the Hu and colleagues' New England Journal of Medicine 2019 study, residents reporting mistreatment at least a few times per month had nearly threefold increased odds of burnout, a finding that was highly reliable and almost certainly not due to chance. The same pattern held for suicidal thoughts, where mistreated residents showed roughly triple the odds compared to those not mistreated, again with strong statistical confidence that this was a real effect. There was a stepwise dose response. Residents harassed a few times per year showed roughly double the odds of burnout, while those harassed a few times per month or more showed nearly triple the odds. Here's the thing. The gender gap in burnout, with women at 42.4% versus men at 35.9%, disappeared entirely after adjusting for mistreatment. Once mistreatment was accounted for, women and men had essentially identical burnout rates, with no meaningful gender difference remaining. That suggests mistreatment, not gender per se, may explain the disparity. Among mid-career academic medical faculty, workplace sexual harassment in the past 2 years was associated with more than double the odds of personal burnout and nearly triple the odds of work-related burnout, both findings reaching strong statistical significance, indicating these were real and reliable associations. Depression and anxiety are well-documented consequences of sexual harassment exposure. Among French medical students, exposure to sexism and sexual harassment was associated with more than double the odds of depression compared to unexposed peers, a statistically significant finding that was highly unlikely to be explained by chance alone. Post-traumatic stress disorder is similarly linked. Among female nurses in Iran, a sample of 283 participants, 39.1% reported sexual harassment and 13.4% screened positive for PTSD. Sexual harassment was significantly associated with PTSD symptoms, with each incremental increase in harassment exposure corresponding to a meaningful and statistically reliable increase in PTSD symptom severity. The relationship between workplace sexual harassment and suicidality is among the most alarming findings in the literature. A Swedish prospective cohort study of 85,205 participants with a mean follow-up of 13 years found that workplace sexual harassment was associated with nearly a threefold increase in suicide risk, a finding that was statistically significant and not attributable to chance. The same study found that harassment was associated with roughly a 60% increase in suicide attempts, again a reliable and significant association. These associations persisted after adjustment for baseline health and work characteristics, with no obvious differences between men and women. In a later multi-cohort study and meta-analysis of 205,048 participants, workplace violence was associated with a 25% increase in suicide risk after full adjustment for confounding factors, a modest but statistically reliable elevation. There was a dose-response relationship, with frequent exposure carrying a 75% increase in risk versus only a 27% increase for occasional exposure. More recently, a 2025 study found a significant positive relationship between workplace sexual harassment and suicidal ideation in female nurses, mediated by social stigma and moderated by job insecurity. Chronic workplace harassment has significant direct associations with psychological distress and alcohol misuse at long-term follow-up, as demonstrated by a 25-year longitudinal study. The cardiovascular consequences are equally concerning. A study of 304 midlife women found that those with a history of workplace sexual harassment had greater than twofold increased odds of hypertension, a statistically significant and clinically meaningful elevation. The same women showed nearly double the odds of clinical insomnia, again a reliable finding unlikely to be due to chance. The systolic blood pressure increase was approximately 4 millimeters of mercury, corresponding to roughly 20% increased cardiovascular disease risk. The inverse relationship between sexual harassment and job satisfaction is one of the most consistent findings in the literature, stable across more than 30 years of research. Among oncologists, past year sexual harassment by peers and superiors predicted turnover intentions at statistically significant levels, and a Norwegian national sample of 8,800 registered nurses found a strong association between workplace aggression exposure and intention to leave. The consequences of workplace sexual harassment extend beyond the individual clinician to the patients they serve. A systematic review of 36 studies found that unacceptable behavior between healthcare workers, including harassment, negatively affects clinical performance, quality of care, and patient outcomes, including self-reported delays in testing and post-operative complications. A 2025 Cochrane review found no eligible studies evaluating education and training interventions to prevent sexual harassment in healthcare workers, highlighting a fundamental gap between the scale of the problem and the evidence base for solutions. Understanding why healthcare is a high-risk industry for sexual harassment requires examining the structural and cultural characteristics of healthcare organizations. The EEOC's 2016 report of the co-chairs of the Select Task Force on the Study of Harassment in the Workplace identified a set of organizational risk factors that increase the likelihood of harassment. These include significant power disparities, high-value employees who are difficult to discipline, workforces dominated by one gender, cultural and language differences, workplaces that rely on customer service or client satisfaction, isolated work sites, decentralized work sites, and workforces with many young workers. Healthcare organizations satisfy nearly all of these criteria simultaneously. Organizational climate, defined by leadership tolerance, transparency, accountability, and the institution's signaled values, is the single strongest predictor of harassment rates. Organizations in which leadership visibly tolerates harassment, in which complaints aren't investigated or backfire on the complainant, and in which gender harassment is normalized show higher rates of sexual harassment of all types. Longitudinal data from a Swedish cohort demonstrated that higher procedural justice and supportive managerial leadership prospectively predicted lower risk of gender-based harassment, providing some of the first longitudinal evidence that these organizational factors are modifiable antecedents rather than mere correlates. Perceived relational injustice and authoritarian treatment by superiors were associated with substantially higher prevalence of sexual harassment, with affected workers experiencing roughly 2 to 3.5 times greater likelihood of harassment exposure. And these effects disproportionately affected women and employees with foreign backgrounds. Healthcare organizations are among the most strongly hierarchical workplaces. Lines of clinical authority, from attending physician over resident, nurse manager over staff nurse, preceptor over student, to physical therapy, clinical instructor over student, produce evaluative and gatekeeping relationships in which the subordinate's ability to complete training, obtain references, or advance depends on the supervisor's discretion. Physical therapy, occupational therapy, nursing, and many allied health roles require sustained physical proximity, frequent therapeutic touch, exposure of body regions during assessment, and one-on-one closed-door treatment. The use of therapeutic touch and extended one-on-one encounters has been explicitly identified as a driver of risk for inappropriate patient sexual behavior toward physical therapists relative to many other professions. An integrative review confirmed that personal care tasks and independent bedside contact are among the highest risk contexts for sexual harassment. Night shift work is one of the most consistently identified modifiable organizational risk factors. A multi-center Chinese study of 4,267 healthcare workers found that absence of night shift work was significantly protective against workplace violence, reducing the odds by approximately 26%, a finding that was statistically reliable and consistent with a meaningful protective effect. A 7-year ecological study at an Italian university hospital found that night shifts per ward were associated with roughly 2.5 times the risk of workplace violence, a statistically significant elevation that was very unlikely to be due to chance. The association was dramatically stronger in psychiatric wards, where night shifts corresponded to nearly 9 times the risk of violence compared to day shifts. Mechanisms include reduced staffing and supervision, increased patient acuity during nighttime hours, and fewer witnesses. Isolated treatment environments, including closed treatment rooms, single patient home visits, single clinician imaging suites, and after-hours diagnostic studies, routinely place a single clinician alone with a single patient without a witness. The Joint Commission, in extending workplace violence prevention requirements to home care organizations effective January 2025, noted that only 48.9% of home care workers had received policies and procedures about workplace violence prevention. Worker isolation and difficulty maintaining professional boundaries in clients' private residences have been identified as key hazards for home care staff. Patient populations on certain units, including psychiatric inpatient, geriatric, acquired brain injury, and dementia care, exhibit elevated rates of disinhibited sexual behavior, some symptom-driven rather than volitional. That complicates response decisions and increases the frequency of IPSB. These structural and cultural factors converge to create a reporting paradox. The same hierarchical, isolated, and normatively permissive conditions that enable harassment also suppress reporting. A study of 317 employees who experienced workplace sexual harassment found that 55% also experienced institutional betrayal, including minimization, retaliation, and failure to act, which was independently associated with decreased job satisfaction, decreased organizational commitment, and increased somatic symptoms. On the other side, institutional courage, characterized by transparency, proactiveness, and supportive responses, appeared to lessen these negative outcomes. Sexual harassment in clinical work environments shows up across 4 principal categories of conduct: verbal, physical, visual, and written or digital. Each encompasses behaviors ranging from subtle boundary violations to overt assault. Healthcare settings produce profession-specific variants that allied health professionals must be equipped to recognize. Verbal harassment includes unwelcome sexual jokes, innuendo, propositions, comments about a person's body or sexual activity, slurs based on sex or sexual orientation, remarks about gender expression, and explicit or implicit demands for sexual contact. In healthcare environments, verbal harassment frequently takes forms shaped by clinical hierarchy. Examples include a physician routinely addressing a female nurse by sexualized nicknames during rounds, co-workers speculating loudly about a colleague's sex life in break rooms, a senior nurse repeatedly questioning a student about dating partners and sexual experiences, or a manager threatening sexual rumors in retaliation for a complaint. A single severe verbal incident may be actionable under the hostile work environment standard established in Harris versus Forklift Systems Incorporated in 1993. Otherwise, verbal conduct typically establishes liability through repetition and pervasiveness. Physical harassment encompasses any unwelcome touching of a sexual nature, including groping, grabbing, brushing against, blocking movement, restraining, and sexual assault. In clinical settings, physical harassment frequently exploits the physical proximity inherent in patient care. Examples include a physician grabbing or smacking a nurse during a procedure, a certified nursing assistant being cornered by a co-worker in a supply closet, or a surgical technologist being kissed without consent in a scrub area. A single instance of physical sexual contact, particularly assault, can establish a hostile environment without proof of pervasiveness. That's consistent with the Supreme Court's recognition in Marital Savings Bank versus Vinson in 1986 that the severity of the conduct reduces the quantum of repetition required for actionability. Visual harassment includes displaying or distributing sexual images, making sexual gestures, leering, and other nonverbal sexual conduct. Healthcare-specific examples include sexually explicit images posted in shared reading rooms, sexually suggestive screensavers on shared clinical workstations, a supervisor regularly leering at staff during shift handoff, and a physician miming sexual acts in the presence of subordinates. Written and digital harassment includes sexual content transmitted through notes, emails, text messages, instant messages, social media, and workplace communication platforms. The expansion of telehealth and team communication tools has extended the reach of harassment into video meeting backgrounds, direct messages on workplace platforms, and clinical team chat channels. persistent unwanted sexual texts from a charge nurse to a staff nurse, sexually explicit messages in a clinical team channel, and ongoing sexualized commentary in private group chats that affects in-person interactions on the unit all constitute covered conduct. The off-site location of digital conduct doesn't automatically remove it from Title VII's reach when it materially affects the work environment. Sexual harassment isn't limited to opposite-sex conduct. As we discussed in Module 1, Title VII prohibits same-sex harassment under Oncalay v. Sundowner Offshore Services Incorporated, decided in 1998, and after Bostock v. Clayton County in 2020, sex discrimination protections extend to sexual orientation and gender identity, though the application of Bostock to harassment claims remains unsettled following the EEOC's January 2026 rescission of its 2024 enforcement guidance. Healthcare examples include a male nurse subjected to sustained sexual taunting by male coworkers, sexual touching between same-sex staff in a procedure room, and persistent gender stereotype-driven mockery of a female surgeon by a female chief. Title VII protects employees against harassment by non-employees, including patients, patients' family members, visitors, vendors, and contractors, when the employer knew or should have known of the harassment and failed to take prompt and appropriate corrective action. Most federal circuits apply this negligence standard. In Bivens v. Zepp Incorporated, decided by the Sixth Circuit in August 2025, the Sixth Circuit adopted a narrower intent-based standard, holding that an employer is liable only if it intended for the harassment to occur or was substantially certain harassment would result. This minority approach is binding only in the Sixth Circuit, which covers Kentucky, Michigan, Ohio, and Tennessee. Illinois sits in the Seventh Circuit, where the negligence standard remains controlling. Under Illinois law, the IHRA mirrors the negligence formulation. Third-party harassment is particularly prevalent in healthcare because of the physical proximity and intimacy inherent in patient care. As we documented in Module 2, career prevalence of inappropriate patient sexual behavior among physical therapists and physical therapy students exceeds 80%. Reported behaviors range from sexual comments and requests for non-clinical contact to deliberate genital exposure during therapy, grabbing during transfers, attempts to kiss or fondle, and sexual propositions. Approximately 46.6% of sexually harassed nurses in a systematic review were harassed by patients, and 27.7% were harassed by patients' family members. Behaviors include comments on nurses' bodies, blocking nurses in patient rooms, sending sexual messages after discharge, and propositioning home health aides during visits. The risk is particularly acute during personal care tasks. The close bodywork of nursing, which involves breaking social rules and normalized physical boundaries, is easily misinterpreted by some patients as sexual. Nursing students are particularly hesitant to respond assertively to sexually aggressive patients because their education emphasizes the caring role. Care workers frequently distinguish between intentional and unintentional sexually inappropriate behaviors from cognitively impaired patients, reframing such conduct as a symptom rather than harassment. However, the psychological impact on the worker may be equivalent regardless of the patient's cognitive status. Patient populations in psychiatric, geriatric, and brain injury care settings exhibit elevated rates of disinhibited sexual behavior. When third-party harassment is identified, appropriate employer corrective action includes removing the harassed clinician from contact with the offending patient without economic penalty, reassigning the patient to a different provider, issuing a written warning or no-contact directive, adjusting visitation rules, using a same-sex provider chaperone, and, in extreme cases, transferring care to another facility or discontinuing non-urgent services consistent with patient abandonment requirements. Involvement of security, social work, and law enforcement should be pursued when warranted, and all incidents and responses must be documented. As we discussed in Module 1, courts evaluating hostile work environment claims apply the disjunctive severity or pervasiveness standard under a totality of the circumstances analysis, weighing the frequency, severity, physical threat, humiliation, and interference with work performance of the alleged conduct. Healthcare settings introduce a complicating factor in severity analysis when the harasser is a patient with documented cognitive impairment. While the patient's cognitive status may inform clinical response protocols and mitigate punitive measures directed at the patient, it doesn't relieve the employer of its obligation to protect the employee from a hostile work environment. The employer's duty to take prompt corrective action attaches upon actual or constructive knowledge of the harassing conduct, regardless of the harasser's intent or cognitive capacity. Healthcare workers who experience or witness sexual harassment should follow a structured reporting approach that balances immediate safety, evidence preservation, and the activation of institutional and legal protections. The literature, EEOC Promising Practices Guidance, and major healthcare employer policies converge on a layered sequence that begins with personal safety and proceeds through documentation, internal channels, anonymous reporting, external agency filing, and, where necessary, legal consultation. The first priority is personal safety. When the conduct involves sexual assault, threat of violence, or active physical contact, immediate steps include leaving the area, contacting security, and where appropriate, calling 911. If sexual assault has occurred, the affected worker should consider time-sensitive forensic examination, typically within 72 to 96 hours. Contemporaneous documentation should begin as soon as safety is secured. Each entry should record the date, time, location, identity of the alleged harasser, what was said or done, names of witnesses, and any physical evidence or communications. Documentation made close in time to the event is generally given greater evidentiary weight than retrospective reconstruction. Evidence, including text messages, emails, secure messaging exchanges, and voicemails, should be preserved in a personal off-employer location to the extent legally permissible. Internal reporting through the employer's channels is the next step. Most healthcare employers provide at least 2 reporting channels, typically the direct supervisor and human resources. Larger facilities often designate an ethics and compliance officer, an equal employment opportunity officer, or an ombuds, a confidential independent resource for raising concerns outside the chain of command. When the alleged harasser is the worker's supervisor, the alternative channel should be used. Written reports are preferable to verbal reports because they create a documentary record. Many hospitals maintain 24-hour anonymous ethics hotlines, often operated by third parties, and the Joint Commission's workplace violence prevention standards effectively require accessible reporting channels at accredited institutions. Anonymous reporting initiates organizational awareness and pattern detection, but limits the employer's ability to conduct a full investigation. External agency filing is available within the applicable statutory window. In Illinois, a charge may be filed with the EEOC within 300 days or with the Illinois Department of Human Rights within 2 years, effective January 1, 2025, under Public Act 103-0973. Internal complaints to the employer don't toll these deadlines. That means a healthcare worker who exhausts internal channels without resolution must still file within the statutory period to preserve the right to pursue legal remedies. The EEOC and IDHR operate under a work-sharing agreement, and charges filed with one agency are typically cross-filed with the other. The Illinois Department of Human Rights also maintains a sexual harassment and discrimination helpline at 877-236-7703, with TTY access via 711. Where the conduct is severe, where the employer's response has been inadequate, or where retaliation has occurred, consultation with plaintiff side employment counsel is advisable. Title VII's anti-retaliation provision makes it unlawful for a covered employer to discriminate against any employee because the employee has opposed any practice made unlawful by Title VII, known as the Opposition Clause, or has made a charge, testified, assisted, or participated in any EEOC investigation, proceeding, or hearing, known as the Participation Clause. Crawford v. Metropolitan Government of Nashville and Davidson County decided in 2009 expanded the Opposition Clause. The court held that employees who oppose harassment by answering questions during an employer-initiated internal investigation are protected even if they didn't initiate the complaint. The standard for actionable retaliation was established in Burlington Northern and Santa Fe Railway Company v. White, decided in 2006, which defined a materially adverse action as one that might have dissuaded a reasonable worker from making or supporting a charge of discrimination. This standard is deliberately broader than the substantive discrimination standard and captures a wide range of employer conduct. In healthcare settings, materially adverse retaliatory actions have included reassignment to less desirable shifts or units, denial of promotion, exclusion from professional training or continuing education opportunities, refusal to provide references, sham performance investigations, suspension without pay, unfavorable performance reviews initiated after a complaint, and creation of a hostile work environment in retaliation for reporting. Former employees are also protected. Robinson v. Shell Oil Company, decided in 1997, holds that post-termination negative references constitute actionable retaliation. The causation standard for Title VII retaliation claims is but for causation, as established in University of Texas Southwestern Medical Center v. Nassar in 2013. This is a stricter standard than the motivating factor test applied to substantive discrimination claims, meaning the complainant must demonstrate that the adverse action wouldn't have occurred absent the protected activity. Despite this heightened standard, the EEOC's enforcement data show that retaliation remains the single most frequently filed charge category. Illinois provides 2 principal state law sources of anti-retaliation protection for healthcare workers. Section 6-101 of the Illinois Human Rights Act prohibits retaliation against any person who opposes what the person reasonably and in good faith believes to be a civil rights violation under the Act, or who files a charge, testifies, assists, or participates in an IHRA proceeding. Retaliation claims under the IHRA follow the same procedural framework as substantive claims, including the 2-year statute of limitations effective January 1, 2025. The Illinois Whistleblower Act provides additional protection by prohibiting retaliation against an employee who discloses to a government or law enforcement agency information the employee reasonably believes evidences a violation of state or federal law, or who refuses to participate in an activity the employee reasonably believes would violate law. Under 2024 amendments, effective January 1st, 2025, the Act's protections were further expanded to include additional categories of protected disclosure activity. The Whistleblower Act applies to all Illinois employers with one or more employees and provides remedies including reinstatement, back pay, compensatory damages, and attorney's fees. Internal complaints alone, without disclosure to a government or law enforcement agency, may not be covered by the Whistleblower Act, but are protected under the IHRA's anti-retaliation provision and under Illinois common law retaliatory discharge. Additional protections may apply under the Occupational Safety and Health Administration, or OSHA, whistleblower provisions for reports of unsafe working conditions, and under State Professional Licensing Board protections for licensed nurses and other healthcare professionals who report violations of practice acts. Thorough, contemporaneous documentation is one of the most important evidentiary tools available to healthcare workers who experience sexual harassment. Each incident log entry should include the date and time with day of week, specific location, identity and title of the alleged harasser, a factual description using direct quotes where possible, whether physical contact occurred, the worker's response, names and titles of witnesses with notation of what each observed, and any physical or psychological effects on the worker. The log should be updated after each incident rather than reconstructed in batch, as contemporaneous records carry substantially greater evidentiary weight. Evidence preservation extends beyond the incident log. Workers should save text messages, emails, secure messaging exchanges, and voicemails, forwarding them to a personal account where the system permits, or photographing and screenshotting where it doesn't. Workplace records, including schedules, badge swipe records, and patient assignments, can corroborate that the worker and the alleged harasser were present at the same time and location. These may be requested under the Illinois Personnel Record Review Act. Prior performance records, particularly those predating the complaint, are critical for rebutting employer claims that adverse actions were performance-based rather than retaliatory. Workers shouldn't access others' files, restricted systems, or information protected by the Health Insurance Portability and Accountability Act, or HIPAA, outside their role-based access. Surveillance footage has short retention periods, often 7 to 30 days, and should be requested immediately. Witnesses relevant to legal proceedings fall into several categories: direct fact witnesses who observed the harassing conduct, pattern witnesses who experienced similar conduct from the same alleged harasser, outcry witnesses who were the first people told about the incident, supervisory or human resources personnel whose response or failure to respond is relevant to employer liability, and treating clinicians whose records document the worker's psychological response and its relationship to the harassment exposure. A consolidated chronology tying these elements together should include the worker's date of hire and role history, each documented incident in date order, each report and the response received, subsequent adverse actions, comparable treatment of other employees, and the worker's health timeline as relevant to damages. For healthcare workers in Illinois, the critical filing deadlines are 300 days from the most recent act of discrimination for a charge with the EEOC and 2 years from the most recent act for a charge with the IDHR, effective January 1st, 2025, under Public Act 103-0973. The continuing violation doctrine, established in National Railroad Passenger Corporation v. Morgan in 2002, permits consideration of incidents outside the limitations window for hostile work environment claims, so long as at least one contributing incident falls within the filing period. Internal complaints don't toll these external filing deadlines. That makes it essential that workers maintain awareness of the statutory windows throughout the documentation and reporting process. Having covered the legal definitions, prevalence data, recognition skills, and reporting procedures in the preceding modules, let's now turn to employer obligations for prevention, investigation, and corrective action, and examine which strategies the evidence supports. Effective sexual harassment prevention begins with a thorough written policy that satisfies both legal standards and organizational best practices. The EEOC's 2017 Promising Practices for Preventing Harassment identifies the essential elements of a credible anti-harassment policy. These include a clear and unequivocal prohibition of harassment, definitions and examples of prohibited conduct, multiple complaint channels so that employees aren't forced to report to the alleged harasser, a description of the investigation process, a clear non-retaliation guarantee, a commitment to confidentiality consistent with a thorough investigation, and a statement of disciplinary consequences. These features aren't merely aspirational. Under the Farragher-Ellerth Affirmative Defense Framework, an employer that has failed to adopt and disseminate an effective policy will have difficulty demonstrating that it exercised reasonable care to prevent and promptly correct harassing behavior. In Illinois, Public Act 101-0221, the Workplace Transparency Act, requires all employers with employees working in Illinois to provide annual sexual harassment prevention training, complying with Section 2-109B of the IHRA. Section 2-110 imposes additional written policy and supplemental training requirements for restaurants and bars. The City of Chicago Ordinance, effective July 1, 2022, adds further requirements. 1 hour of sexual harassment prevention training for all employees, 2 hours for supervisors and managers, and 1 hour of bystander intervention training for all employees annually. The Illinois Department of Human Rights provides model policy and training materials at no cost. Research demonstrates that the mere existence of a written policy isn't sufficient without visible leadership commitment. A study of 805 companies over 32 years found that leadership behavior mediated the relationship between formal policy and organizational outcomes. Women who perceived that their leaders made honest efforts to stop harassment felt significantly freer to report, were more satisfied with the complaint process, and reported greater organizational commitment. The bottom line is that policies produce measurable results only when leaders actively enforce them and signal genuine intolerance for harassing conduct. State-mandated training programs represent the regulatory minimum. Illinois requires annual training, including an explanation consistent with the IHRA, examples of prohibited conduct, a summary of federal and state statutory provisions, and a summary of employer responsibilities. California mandates 2 hours for supervisors and 1 hour for non-supervisory employees every 2 years under SB 1343. Connecticut, Delaware, Maine, New York, and Washington impose similar requirements with varying duration and frequency parameters. The evidence on training effectiveness is mixed and warrants careful interpretation. The 32-year analysis of 805 companies found that manager training, which encouraged managers to identify signs of trouble and intervene proactively, was followed by increases in women managers. Traditional employee compliance training, which prescribed specific behaviors and implicitly signaled male trainees as potential perpetrators, was followed by decreases in managerial diversity. Grievance procedures alone were associated with retaliation against complainants without satisfying their concerns. A 2022 systematic review of policies and interventions found limited evidence that training reduces actual harassment incidents, with most studies measuring improvements in knowledge and attitudes rather than behavioral or incidence outcomes. The NASM 2018 consensus report concluded that traditional legalistic compliance training, the type most commonly mandated by state law, hasn't been shown to reduce harassment and may produce backlash effects in some populations. Programs that focus on bystander intervention, organizational climate improvement, and civility promotion demonstrate more promising results than narrow rules-based instruction. When an employer receives actual or constructive notice of potential harassment, the obligation to investigate attaches immediately. One published institutional protocol at the Icahn School of Medicine at Mount Sinai requires triage of mistreatment reports within 24 hours of submission. EEOC guidance directs employers to investigate promptly without specifying a numeric timeline, and SHRM and the Association of Workplace Investigators similarly recommend prompt investigation without codifying specific day count benchmarks. Delay alone can defeat the Farragher-Ellis defense. Under that Mount Sinai protocol, egregious or patterned behavior was escalated to formal investigation immediately. Impartiality requires that the investigator be free of conflicts of interest. Where the alleged harasser occupies senior leadership, the investigator should be external counsel or an outside professional with training in employment law fundamentals, trauma-informed interviewing, and cognitive bias mitigation. McLean published the first detailed framework in 2022 addressing cognitive bias in workplace investigations, noting that the sources, magnitude, and direction of bias are specific to workplace environments. The same study's experimental findings demonstrated that non-factual witness claims significantly bias investigators' judgments about event causation, and that background information about a worker's history causes investigators to misclassify uncheckable claims as potential facts. Debiasing strategies include structured interview protocols, sequential unmasking, which means presenting evidence to investigators in stages to prevent bias, explicit consideration of alternative hypotheses, and peer review of findings. The investigative sequence proceeds from the complainant interview, conducted with a trauma-informed approach allowing sufficient time through identified corroborating witnesses, then the alleged harasser with notice of allegations sufficient to permit meaningful response but without disclosure that could enable interference and follow-up rounds as needed. Evidence collection should encompass documents, electronic communications, schedules, badge swipe records, surveillance footage, prior complaints concerning the same individual, and personnel files of the parties. Fragmented data systems across human resources, medical staff offices, and compliance departments represent a documented barrier to detecting patterns of serial misconduct in healthcare organizations. Integrated systems for identifying, storing, and retrieving behavior of concern have been specifically recommended. Investigators may promise confidentiality only to the extent consistent with a thorough and impartial investigation. Blanket confidentiality directives can implicate Section 7 National Labor Relations Act rights. Reasonable interim measures during investigation, such as schedule separation, paid administrative leave, and alternative reporting lines, shouldn't unduly burden the complainant. Corrective measures must be calibrated to findings, escalated for recidivists, and followed by periodic check-ins for several months to verify that harassment has ceased and no retaliation has occurred. Healthcare employers face a multi-layered regulatory environment extending substantially beyond Title VII and the IHRA. The Joint Commission's Workplace Violence Prevention Standards, effective January 1, 2022 for all accredited hospitals and critical access hospitals, define workplace violence to expressly include sexual harassment. They require a designated leader, a multidisciplinary prevention team, defined incident reporting and investigation processes, data collection and analysis, post-incident support for staff, and training. More than 100 requirements for improvement related to workplace violence have been cited since these standards took effect. Effective January 2026, workplace violence prevention is elevated to a national patient safety goal with 3 elements of performance: a program led by a designated individual, training, education, and resources at hire, annually, and whenever program changes occur, with documentation required. An annual worksite analysis including investigation of incidents and assessment of how policies reflect best practices, with documentation required. OSHA enforces workplace safety and healthcare under the General Duty Clause. By January 2019, OSHA had initiated 726 workplace violence inspections, with the vast majority, roughly 7 in 10, occurring in healthcare settings. Among those healthcare inspections, approximately 1 in 9 resulted in General Duty Clause citations, and roughly 2/3 resulted in hazard alert letters. Facilities receiving citations had significantly lower scores across 5 of 6 prevention program domains. Those proportions reflect subset denominators reported in the original analysis, not the full set of healthcare inspections. California's SB 1299, enacted in 2014, led to the California Division of Occupational Safety and Health's 2017 healthcare-specific workplace violence prevention regulation, the first enforceable standard of its kind, and nearly 40 states have since enacted laws addressing workplace violence against healthcare workers. State boards of nursing, physical therapy, occupational therapy, and medicine maintain codes of professional conduct, prohibiting boundary violations and sexual misconduct, with disciplinary consequences for licensees and employer reporting obligations to the relevant board and to the National Practitioner Databank for clinical privileges actions. Evidence-based prevention in healthcare requires an integrated multi-component approach rather than any single intervention. A Veterans Health Administration study of 180 healthcare staff found that bystander intervention training significantly decreased barriers to intervening and increased awareness, self-efficacy, and intentions to act, with the belief that harassment is a workplace problem rising from 42.4% to 75% post-training. A 2025 scoping review of 14 studies confirmed that bystander training workshops incorporating practice exercises can increase pro-social bystander behavior, though long-term efficacy evaluation remains limited by the paucity of follow-up measurements. No studies have demonstrated that bystander training alone reduces harassment incidents. The NASEM report recommends diffusing trainees' dependence on single supervisors through mentoring networks and committee-based advising structures, thereby flattening the hierarchical power concentrations that enable harassment. An institutional initiative combining a no-abuse policy, an ombuds office, improved reporting, workshops, and grand rounds was associated with a decrease in reported medical student mistreatment from 62.9% to 40.3% over 6 years. The incidence of sexual harassment specifically remained unchanged at 13.4%, suggesting that general mistreatment and sexual harassment may require distinct intervention strategies. For patient-generated harassment, recommended protocols include explicit inappropriate patient sexual behavior training in clinical curricula, pre-treatment risk review and chaperoning where indicated, clinician scripts for direct response to inappropriate behavior, same-sex chaperoning where appropriate, documentation in the patient record, treatment team escalation procedures, and discontinuation of non-urgent services in confirmed pattern cases, consistent with abandonment and professional ethics requirements. Education on IPSB in physical therapy and occupational therapy curricula increases student preparedness and reduces post-incident psychological harm. The Mayo Clinic's institutional approach, combining clearly defined policies, systematic investigation methods, fair and consistent corrective actions, and targeted culture development, exemplifies the multi-component model. To bring this all together, a defensible prevention program integrates written policy meeting Farragut-Ellerth criteria, annual training with bystander intervention content, healthcare-specific IPSB protocols, multiple reporting channels, periodic climate measurement with leadership accountability, prompt impartial investigation, visible corrective action, and retaliation monitoring. Thank you for completing this course. We will now review the exam questions to solidify your understanding. Question 1. In the Hu et al. New England Journal of Medicine study of general surgery residents, what happened to the gender gap in burnout rates after adjusting for mistreatment? The correct answer is C. The gender gap disappeared entirely, with no meaningful difference remaining. Rationale: the gender gap in burnout, with women at 42.4% versus men at 35.9%, disappeared entirely after adjusting for mistreatment. Once mistreatment was accounted for, women and men had essentially identical burnout rates, with no meaningful gender difference remaining, suggesting mistreatment, not gender per se, may explain the disparity. Question 2. In Harris v. Forklift Systems Incorporated, 1993, the Supreme Court established that a hostile work environment claim requires which of the following? The correct answer is D, both an objective finding that a reasonable person would find the environment hostile and a subjective finding that the victim perceived it as abusive. Rationale: Harris v. Forklift Systems Incorporated refined the hostile environment standard by establishing a two-part test. The conduct must create an environment that a reasonable person would find hostile or abusive, which is the objective component, and that the victim subjectively perceived to be abusive, which is the subjective component. Question 3. According to the research discussed in this course, which of the following is a modifiable organizational risk factor consistently associated with increased workplace violence in healthcare settings? The correct answer is A, night shift work. Rationale: night shift work is identified as one of the most consistently identified modifiable organizational risk factors. A multi-center Chinese study found that absence of night shift work was significantly protective against workplace violence, reducing the odds by approximately 26%. A 7-year Italian study found that night shifts were associated with roughly 2.5 times the risk of workplace violence. Question 4. Under the EEOC's regulations at 29 CFR Section 16, 04.11, which of the following best describes sexual harassment? The correct answer is B. Unwelcome sexual advances, requests for sexual favors, or other conduct of a sexual nature that affects employment terms, employment decisions, or the work environment. Rationale: the EEOC's regulations define sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission is made a term or condition of employment, when submission or rejection is used as the basis for employment decisions, or when the conduct unreasonably interferes with work performance or creates an intimidating, hostile, or offensive working environment. Question 5. A certified nursing assistant reports that over the past month, a co-worker has been making regular comments about their body and telling sexual jokes during breaks. Yesterday, the same co-worker cornered them in a supply closet and made unwelcome physical contact of a sexual nature. Based on the categories of harassment discussed in this course, which type of harassment does the most recent incident in this scenario primarily represent? The correct answer is A, physical harassment. Rationale: physical harassment encompasses any unwelcome touching of a sexual nature, including groping, grabbing, brushing against, blocking movement, restraining, and sexual assault. The course specifically identifies a certified nursing assistant being cornered by a co-worker in a supply closet as an example of physical harassment in clinical settings. Question 6. A physical therapist working in an outpatient rehabilitation clinic reports that a colleague regularly comments on her body, tells sexual jokes during team meetings, and has twice asked her out despite clear refusal. According to the categories of harassing conduct discussed in this course, which form of sexual harassment does this pattern primarily represent? The correct answer is C, verbal harassment. Rationale: verbal harassment includes unwelcome sexual jokes, innuendo, propositions, comments about a person's body or sexual activity, slurs based on sex or sexual orientation, and persistent romantic overtures despite refusal. The scenario describes a pattern of verbal conduct, including body comments, sexual jokes, and repeated unwelcome date requests that falls squarely within the verbal harassment category. Question 7. According to the reporting framework discussed in this course, what is the recommended first priority when a healthcare worker experiences workplace sexual harassment involving physical contact or threat of violence? The correct answer is D, ensure personal safety by leaving the area and contacting security or calling 911 if appropriate. Rationale: the course identifies a structured reporting sequence that begins with personal safety and proceeds through documentation, internal channels, external agency filing, and legal consultation. When the conduct involves sexual assault, threat of violence, or active physical contact, the first priority is leaving the area, contacting security, and, where appropriate, calling 911. Documentation, internal reporting, and external filing are all important subsequent steps, but they follow after personal safety has been secured. Question 8. According to the EEOC's Promising Practices for Preventing Harassment, which of the following is an essential element of a credible anti-harassment policy? The correct answer is B, multiple complaint channels so employees are not forced to report to the alleged harasser. Rationale: The EEOC's Promising Practices identifies essential elements of a credible anti-harassment policy, including multiple complaint channels, so that employees are not forced to report to the alleged harasser. Other essential elements include clear prohibition of harassment, definitions and examples, a description of the investigation process, a non-retaliation guarantee, confidentiality commitment, and a statement of disciplinary consequences. Question 9. After filing an internal sexual harassment complaint, a physical therapist is moved from a high-volume outpatient caseload to a lower-volume home health territory, adding 90 minutes to her daily commute. Her base salary remains unchanged. Under Burlington Northern and Santa Fe Railway Company v. White, 2006, this action qualifies as unlawful retaliation when it meets which standard? The correct answer is B. The action might have dissuaded a reasonable worker from making or supporting a charge of discrimination. Rationale: Burlington Northern and Santa Fe Railway Company v. White defined a materially adverse action as one that might have dissuaded a reasonable worker from making or supporting a charge of discrimination. This standard is deliberately broader than the substantive discrimination standard and captures a wide range of employer conduct beyond termination or demotion. Question 10. In the Veterans Health Administration study on bystander intervention training, which of the following outcomes was reported? The correct answer is A. The belief that harassment is a workplace problem rose from 42.4% to 75% post-training. Rationale: The Veterans Health Administration study of 180 healthcare staff found that bystander intervention training significantly decreased barriers to intervening and increased awareness, self-efficacy, and intentions to act. Specifically, the belief that harassment is a workplace problem rose from 42.4% to 75% post-training. Thank you for completing this exam review. We hope the material strengthens your understanding and supports your continued commitment to safe, respectful clinical environments.